All right, welcome to another Ramos Law verdict breakdown. Today we have the man, the myth, the legend, Matt Osborne, absolute machine, and we're talking about Panchenko versus Comenity. You will not believe the verdict that he got in this case. Matt, could you tell us first just a little bit about the case and what the claims were?
Yeah, so we represented Alexander Panchenko against Comenity Bank. Basically, he came to America in 2013 to work as a hotel, basically cleaning rooms for a summer. So they gave him a social so he could pay taxes. And then he went back to Ukraine. And then when he was living in Ukraine, a thief stole his social somehow, opened up about 10 different credit cards in his name, and basically lived as him for several years. When the Russia-Ukraine war broke out, he fled Ukraine and came to America and couldn't get any credit because he had 10 defaulted credit cards on his credit file that this thief had opened up.
That's a rude awakening. What venue were you in?
We were in the Northern District of California in San Jose in federal court.
Federal court. And how many parties were there?
Yeah, we originally, I think, had about 9 defendants, and all of them settled except for Comenity.
So Comenity was the last man standing, I guess.
Right. And basically one of their big defenses was, hey, this person's already been paid like 8 other times, so why should he be paid again?
Okay, I see. So were they telling the jury that explicitly, or were they insinuating it? What were the rules of evidence allowing with that?
Yeah, so they were allowed to discuss the fact that we had sued other people and settled, but the jury wasn't allowed to know the amounts they paid or the terms of the settlement.
Oh, okay. Very cool. And what claims did you bring on your underlying case?
We just had one claim, Fair Credit Reporting Act, for both willful and negligent violations.
Okay. And what was at stake? I mean, what was the amount in issue?
Well, we didn't actually ask the jury for a specific amount, so we weren't sure what we might win. But going into it, they had only offered us, I think, about $40,000, and that was after we had hundreds of thousands in fees in the case, and the client didn't want to accept it. So just kind of went into trial not really knowing what might happen.
And, for the people who don't know, like me, what are the economic damages, or what are the components of damages you're looking to collect in a Fair Credit Reporting Act case?
Well, it's usually going to be non-economic damages for embarrassment, frustration, inconvenience, wasted time spent disputing it, being embarrassed when you get turned down for loans, things like that. And then you can also get punitive damages, and then you can get attorney's fees and costs if you win.
Okay. Is there any economic component to where, hey, I was unable to get credit and it cost me this house or job or whatever?
I mean, you can get economic, but it's hard to quantify exactly because most credit scores are based on a variety of factors, and it can be hard to pinpoint exactly what the cause was of your score going down on any particular day. And it's also hard to quantify how much you lost from not getting a loan. I mean, we've had a few cases we could do that, but mostly we're not claiming economics.
Okay. And on this case, what were your components of damages you were claiming?
Just emotional distress and punitive damages.
Okay. Now, we haven't said it yet, but the verdict was crazy. Why don't you break down the verdict, the actual numbers that you ended up getting?
Okay, so we got 100,000 in emotional distress, and then we got 20 million in punitive damages.
Wow. It might have been an eye-opening with the previous $40,000 offer.
Yeah, the defendants looked shell-shocked when it was read.
You got to describe to me a little bit, like what. I want to hear both. Like, what did the defendants look like? Oh, how many attorneys did they have sitting there?
They had 3 attorneys, and then they had their general counsel that they flew in as well.
Were all 4 like in the attorney area?
The general counsel was sitting at counsel table, but he didn't speak or testify.
All right. Describe their faces when that verdict got read. General counsel, were you looking at him?
I was actually looking at the jury, but I mean, I looked at them over right after they read it, and they just looked shell-shocked. I mean, they were just completely in disbelief.
Did they shake your hand, and were they like, "Hey, good one, good trial," or were they just out of there?
No, they did shake our hand and say congratulations, and I mean they were good sports about it. So,
oh, that's good. And then what was that moment like for your client? Right? I mean, your client, presumably he was sitting there the whole trial, watching everything. He gets this huge number. What was that like?
Well, he told me going into the trial that he's like, I don't want to be on the news. And then when he saw my closing argument, he said, that was so good, I think we might be on the news. And then when it was read, he was like, oh, man. But he was also really happy because, I mean, they had basically accused him of faking his damages, and they sort of insinuated that he allowed it to happen on purpose. You know, they didn't exactly say that, but they kind of insinuated that maybe he sold his social, which he didn't do. So he was, you know, he felt vindicated by the finding for sure.
Yeah. And obviously getting the final judgment and all of that, did you have to talk through with your client like, well, let's not start spending the 20 million just yet? Or how'd that go?
Yeah, we definitely told him that. And because, it's a process. They're trying to get it reduced. And if that doesn't work, they're going to take it to the Ninth Circuit. So there's a lot of post-trial briefing that's still going to happen. But he wasn't in it for the money. He has a good job, and he works as, in the tech industry there in San Jose. So he's not like dying for the money or anything. It was more of just the principle.
And you said that he saw your closing and he was like, oh, man, that was good. What did you do in closing that, worked out so well?
Well, I think the 2 biggest things, the first one would be that one of their defenses was, hey, you sued like 9 other people and they all settled, so you've been paid. I kind of flipped it on them, and I told the jury, this shows you that the entire industry is messed up. And until you punish them, the whole industry is going to continue to be messed up. Just like there was a time when all the car companies said that it was safe to not have airbags and no seatbelts. And there was a time when all the tobacco companies said it's safe, or cigarettes are safe. I said, this is the modern era of that, and this is your chance to speak directly to the banking industry themselves. And Comenity has volunteered to be the poster boy. And so you can tell them what you think about their practices. And then when it came time to punitive damages, I went and I looked at their lawyer, their general counsel, and I said, I know this dude here didn't say anything, but he's like really high up. He's the general counsel. I want you to write a number that's so big that he asks to be excused. And he goes out in the hallway and he calls back the CEO and he says, you're not going to believe what this jury from San Jose just did. I say, you do that and their practices will change. But if you just write some small number, they'll just pay it from their petty cash account and just keep doing this to people.
Did you get any objections during that line of argument?
No.
Oh, that's good. That's good. There's another interesting thing you told me about this case, which was that they played like extreme hide the ball and they weren't bringing their witnesses to trial. So you had like a outrageous amount of depositions. Describe that a little bit?
Yeah. So in federal court, you can only subpoena a witness that's within 100 miles of the courtroom. And their 30B6 was in Ohio. And then all the people that investigated his disputes were in India. So they just said, hey, you can't call any of our people to trial. And so we just put on the plaintiff, and then we played about 7 hours of depo clips for the jury. But luckily we got to depose all of the people who work in India, and they had some really interesting things to say. They said that they had to do, I think it was like 38 investigations a day. And if they didn't do that, they'd get disciplined. And if they did that, then they got bonuses to buy things on Amazon and stuff like that. They said that
like Amazon gift cards?
Yeah.
Like that's what they would get for a bonus?
Yeah, they would give them gift cards to buy things. They basically didn't train them to do anything. Like they testified they didn't even know what a police report was. The only thing that they would look at is, did somebody make a payment? And that was it. And in this case, the thief actually made payments for years to build up his score so that they could take out even more, credit cards.
Oh, jeez.
So they basically trained him to proceed on a false assumption that if a payment is ever made, then it's automatically can't be fraud.
I see. I'm sure the thieves figure that out eventually.
Oh, yeah, because, in the grand scheme of things, you can actually build up somebody's score by making payments and then get even more credit. So you could start with $6,000 in credit line and take it to $150,000 with some few years of payments.
Then you do that multiple times, get the big line, and then bail out on it?
Right. Yeah, and that's what happened here.
So now I wouldn't even have thought to start deposing people in India. They didn't have any problem with you deposing them during litigation?
Well, they tried at first. They tried to say that you had to go through the Hague Convention and get an Indian judge to subpoena them and so forth, but the judge shut them down on that. And since they were actual Comenity employees, they were deemed to be managing agents under 30B1, and therefore they had to give depositions.
Well, it's a good thing you took those depositions, or what would you have done during trial?
If we didn't have those depositions, we probably would not have survived a directed verdict.
Yeah.
That was their whole strategy in not bringing their people to trial.
How many depots total did they take in this, or did you take in this case?
I think 7 or 8.
How did you approach that in the opening? Were you like, we're going to play a really long, boring video for you, or what'd you say?
Yeah, I told the jury, I said, we can only call people to court that are within 100 miles, and all of their witnesses are in other places, and they're too afraid to bring them here, so I have to play you a bunch of boring depots. And I said something like, we'll of course stipulate if they want any of these people to appear by video conference for their testimony. But obviously they didn't take me up on that.
So you're just telling them the court rulings or the rules in your opening to prepare them.
Yeah, because I feel like you have to say something. Otherwise, they're going to just be like, this is really boring, and why are they just playing these? So I think they knew going into it that we didn't want to play the videos, but we didn't have a choice.
Did you call any live witnesses or just plaintiff and depots?
We also called the plaintiff's wife to corroborate his emotional distress and how it affected him.
Wow. And then how long was the defense case?
About 30 minutes. So the judge had us on a time clock. So each side, I think, got 8 hours or somewhere around there. And basically, if you are at the podium and your mouth is moving, that counts against you. So it doesn't matter if you're in opening, voir dire, direct, cross. When you're talking, that counts on your time. So by the time they got to their case in chief, I think they only had like 30 minutes, and they still had to do closing. The judge actually ended up giving them a few extra minutes at the end, because otherwise they would have had to do like a 2-minute closing. So,
how did you agree to the time clock, or did you fight that, or?
No, that was, the judge just imposed that. So,
oh, really?
Yeah.
And he just said, hey, you each get this amount of hours?
I think it's actually a really fair way to do it, though, because I've seen that in other cases where if the judge gives you 5 days, I've seen the defense intentionally do super long crosses, hoping for a mistrial in that you won't be able to finish it in 5 days. So they'll start questioning people for 5-6 hours about irrelevant stuff.
Yeah, I've seen it too, where, you know, you could get the jury kind of where you want them, hopefully, and the defense can kind of feel that, and they're like, let's make sure that we bleed this one into Monday or Tuesday, instead of getting it, you know, let's say closing statements in the morning. So that'd prevent that as well.
Especially if you have a judge that's already booked the next Monday or Tuesday, and they're ready to declare a mistrial if you're not finished by Friday, you know. So I think that's a good rule to prohibit those games and stuff, you know.
Well, have you been able to follow up after it's settled in with your client, and, you know, how's he feeling now?
He feels great. I mean, he's just, he didn't do it for the money. He just did it because he wanted to prove that their system was broken and that things needed to change. And so he just felt vindicated by that.
It's going to be quite a bit of briefing, and still probably just the start of the case, I'm sure. But it's a truly incredible result. $20 million and 100,000 emotional distress. I mean, landmark. Have you gotten any interest or feedback, is that like a record or something?
Yeah, it is the highest FCRA verdict in the country on an individual case. I think the prior record was 18.4 million.
Oh, wow. And so it's the highest in the history of the world.
Yeah, as far as I know, yeah.
As far as you know. Well, awesome, Matt. Well, thank you so much. I mean, you know, truly incredible. Obviously, you have a lot of great trial skills, and, you know, I know you're always more than willing and happy to talk to people about that and strategy and all that. But, I mean, you should be really proud of yourself. I'm very excited for your client. And that'll wrap up another Ramos Law verdict breakdown. Thank you for your time today.